Hi, I'm Greg Smith. Let's talk about retaliation. That is something that your employer cannot do. Now, let's assume you go up to your employer and you say, you know what, boss, I think you owe me for some unpaid overtime. And your boss says, yeah, you're kind of a troublemaker, you're fired. Well, that's obviously retaliation. And but what if your boss doesn't fire you? He just starts to make it really hard on your husband or wife, or one of your friends who works for him, or one of your children. So could that be retaliation? So let's take a look at the law to give you a little bit of an idea of what retaliation can be. So let's take a look at this Thompson versus North American case, and you'll notice that this came out of the United States Supreme Court. So you don't get bigger than that. So the facts in this case, pretty straightforward. It says until 2003, it says both petitioner Eric Thompson and his fiancée Miriam Regalado were employees of North American Stainless, in other words, NAS. And so it says in February of 2003, the Equal Employment Opportunity Commission, better known as the EEOC, notified the employer NAS that Regalado had filed a charge alleging sex discrimination. So then NAS, for whatever reason, fired Thompson, the fiancé. So then Thompson filed a charge with the EEOC. Now remember, when you think there is discrimination on the job site, you have to go to the EEOC and file a complaint. And there are time limits to do this. And you have to, call an attorney immediately if you think you've been discriminated against on the job, or call the EEOC. Now, Utah doesn't have an EEOC. Arizona does, out of Phoenix. Colorado does, out of Denver. But Utah has the Anti-Discrimination and Labor Division, the UALD, and they're downtown on, I think it's 160 East, 300 South. But there are time limitations, and if you're discriminated on the job and you don't file a complaint with the EEOC or the UALD within a certain time period from the date of discrimination, you forfeit your claim. And we're talking months, not years here. So, and if you're a public employee, it's even shorter. And if you're a federal employee, it's also very short. So don't take any chances. Contact an attorney immediately. Well, after the conciliation efforts proved unsuccessful, then this employee sued NAS in the United States District Court for the Eastern District of Kentucky under Title VII of the Civil Rights Act of 1964. Title VII of the 1964 Civil Rights Act provides that it shall be illegal, unlawful. It shall be an unlawful employment practice for an employer to discriminate against any of his employees because he has made a charge under Title VII. This is Section 42, United States Code. All right. The statute permits a person claiming to be aggrieved to file a charge with the EEOC, remember, you got to be quick on this, alleging that the employer committed an unlawful employment practice, and if the EEOC declines to sue the employer, it permits a civil action to be brought by the person claiming to be aggrieved by the alleged unlawful employment practice. So anyway, the leading case on this is the Burlington case. And the court said, you know what, we're going to broadly construe rights here. Broadly construe rights. And so it says, with regard to the first question, we have little difficulty concluding that if the facts alleged by Thompson are true, then NAS's firing of Thompson violated Title VII. And then they go and they cite to this Burlington case. And it says, we held, in other words, in the Burlington case, we ruled that Title VII's anti-retaliation provision must be construed to cover a broad range of employer conduct. We reached that conclusion by contrasting the text of Title VII's anti-retaliation provision with its substantive anti-discrimination provision. In other words, I know that's a lot of legal gobbledygook, but essentially what this is saying, let's assume you go to your boss and you say, you know what, I think you're discriminating against me because I was born in Ireland. And the boss laughs and says, that's ridiculous. And let's suppose the boss can prove the company never discriminated against you because of your national origin, because the nation that you originated from was Ireland. And so the boss just laughs and says, this is ridiculous. And he presents you with an abundance of evidence. And so there's just nothing there. Then the next day, the boss demotes you to send you a message not to bring frivolous complaints to his office in the future. Well, that's retaliation. And that retaliation is broader. So it says here, Title VII prohibits discrimination based on the basis of race, color, religion, sex, and national origin. In this case, you came and said, I think you're discriminating against me because of my national origin, Ireland, with respect to compensation, terms, conditions, or privileges of employment and discrimination practices that would deprive any individual of employment opportunities or otherwise adversely affect his status as an employee. But look at what it says under the anti-retaliation provision. Title VII's anti-retaliation provision. So the boss has established they did not discriminate against you because you were born from Ireland. But he's mad now because you came in, he thinks you're a troublemaker, and now he's going to retaliate against you for being kind of a troublemaker. But the anti-retaliation provision prohibits that employer from discriminating against any of his employees for engaging in protected conduct. So when you went to the boss and said, hey, I think I'm being discriminated against. Now, let's assume you did this in good faith. You weren't just going in there being, an idiot, knowing that you were just razzing him. It has to be that you went there in good faith. So that's called protected conduct. And when you engage in protected conduct, you have protections without specifying the employer acts that are prohibited. So this is really, really big. So in other words, the anti-discrimination statute itself says you cannot discriminate based on race, color, religion, sex, and national origin. 1, 2, 3, 4, 5 things they cannot discriminate against. Now, there are other things that come into play also. But for now, let's just focus on these. But notice the anti-retaliation says, the anti-retaliation part says it does not specify the acts of retaliation that are prohibited. Why? Because there's so many ways an employer can retaliate. And so it says, based on this textual distinction and our understanding of the anti-retaliation provision's purpose, we held that the anti-retaliation provision, unlike the substantive provision, is not limited to discriminatory actions that affect the terms and conditions of employment. Okay, so in other words, again, this is a lot of legal gobbledygook, but essentially, if you feel you've been discriminated against because of your race, your color, your religion, your sex, and your national origin, you have to prove that was affecting your compensation, how much they paid you on your job, or what they had you doing on the job, or the conditions of your work, or privileges of employment, like advancement and things like that. But it narrows those things. It says these things are limited. If your company discriminates against you, you got to prove it was on your compensation. It affected your pay, when you had to show up, when you could leave, and privileges. You have to prove that the discrimination affected one of these 1, 2, 3, or 4 things. Okay? But if you're retaliated against, you don't have to prove that it affected those things. It says, unlike the substantive provision, the anti-retaliation provision is bigger than that. It's not limited to discriminatory actions that affect the terms and conditions of employment. So if your boss goes to your child's elementary school and tells the friends of your 12-year-old child that your 12-year-old child is a brat and they shouldn't play with him, well, that has nothing to do with the terms and conditions of your employment, okay? So, but it says the anti-retaliation provision prohibits any employer's action that well might have dissuaded a reasonable worker from making or supporting a charge of discrimination. So, in other words, if you can say, listen, if you can say to the judge, Your Honor, if a boss can go to my kid's elementary school and tell people my kid is a brat, then other people that work with me are going to see this, and they're not going to want the boss going out and doing this to their children. So they're not going to bring a charge of discrimination. It will have a chilling effect. They're saying we think it's obvious that an employee might not bring an allegation of discrimination if he or she knows that their fiancé is going to be fired or discriminated against. And again, it says Title VII's anti-retaliation provision is worded broadly. All right, now let's finish up here. And again, I know this is a lot of legal gobbledygook, but I want you to read. This is from the United States Supreme Court. So let's see what it says. We expect that firing a close family member will almost always, violate the anti-discrimination or the anti-retaliation test that the Burlington decision talked about. It says, but inflicting a milder reprisal on a mere acquaintance, someone you just kind of know who's on the job with you, or a friend or something, someone from your neighborhood, inflicting a milder, payback or attack on a mere acquaintance of yours will almost never get you to the will almost never prove that retaliation that you can sue for took place. But beyond that, we are reluctant to generalize. As we explained in the Burlington case, the significance of any given act of retaliation will often depend on the particular circumstances. But given the broad statutory text and the variety of workplace contexts in which retaliation may occur, Title VII's anti-retaliation provision is simply not reducible to a comprehensive set of clear rules. We emphasize, however, that the provision's standard for judging harm must be objective, so as to avoid the uncertainties of unfair discrepancies that can plague a judicial effort to determine a plaintiff's unusual subjective feelings. The bottom line here is the court is saying, listen, this is very broad. This is very broad. And if the employer goes after an immediate family member to retaliate, chances are you can sue and that family member can sue. All right. But if they hassle a coworker that you don't know that well, just an acquaintance, then it becomes less and less likely you're going to sue and win on that. Now, let's contrast this to retaliation under the United States Fair Labor Standards Act, okay? In this particular case, it says the wage and hour law only prohibits firing or discriminating against an employee. So if it's the FLSA, it's not as vast, it's not as broad. Now, if there's retaliation in an overtime suit or a minimum wage suit brought in the federal court, it's not as broad. So let's assume you have an overtime case, and then 3 weeks later, your brother who works for the boss gets fired, or your fiancé gets fired. Okay? Under Title VII of the 1964 Civil Rights Act, it's going to be much easier for your brother or your fiancé to sue than if it's an overtime, or in other words, a wage and hour case, because it says the wage and hour law only prohibits firing or discriminating against an employee. And so the defendant would say, well, we didn't fire or discriminate against you. yeah, we fired your brother or your fiance, but that wasn't against you. So when we deal with the United States Fair Labor Standards Act, and here's something out of the 10th Circuit, and the 10th Circuit is the circuit that we are in: Wyoming, Kansas, Oklahoma, New Mexico, Colorado, and Utah. They're in what's called the 10th Circuit. The United States has broken up its courts into circuits. We're in the 10th Circuit. And it says, in this case, Mr. Connor claims to have suffered an adverse employment action, in other words, retaliation, before he was fired. He says specifically, Mr. Connor testified in his deposition that his hours were changed to less desirable times after he claimed overtime wages. So he's saying, my compensation, I came and complained about unpaid wages, specifically overtime. Next thing I know, the terms and conditions of my employment have changed. That's retaliation. And then the court says here in footnote 4, it says to constitute adverse employment action. Okay, so in an overtime case, in order to prove retaliation, which is adverse employment action, the action at issue must relate to the terms and conditions of employment. So it has to specifically be employment related. So in this particular case, if your boss went to school and told some of your kids' friends that your child's a brat, not to play with your child, the defendant could argue that doesn't relate to the terms and conditions of your employment. So you could probably sue for that under Title VII. You'd have a much better chance, I should say, than you would under United States Fair Labor Standards Act claim. Now, a lot of times in these actions, what an employer will do is they will bring a false allegation of theft. So you come to your employer and you say, I don't think I'm being paid overtime. He says, take a hike. You say, no, really, I'm not being paid my overtime. I need to get paid. So next thing you know, he's accusing you of theft or fraud. And this is fairly common. Usually these allegations of theft and fraud don't go anywhere. Why? Because they never accused you of this until you brought up the issue of wages and hours. Okay? So let's assume you sue them and they bring a counterclaim against you for theft or fraud. Okay, that is retaliation. And it says, this is the United States District Court. This came out of New York. Courts have held that baseless claims or baseless lawsuits designed to deter claimants, in other words, to get people who sue, to get employees who sue them to drop their suits or to run away from seeking legal redress, constitutes impermissibly adverse retaliatory actions, even though they do not arise strictly in the employment context. So, when they're talking about taking action, like calling the police, I would argue, to get you to drop your suit or to run away, that's retaliatory, even though it's something that they're doing after you no longer work for them. It's not really affecting a term or condition of your employment because you don't even work there anymore. But it says here, they cite this other case. If an employer files a lawsuit against an employee alleging fraud with a retaliatory motive and without a reasonable basis in fact, that would be retaliatory behavior, an actionable adverse employment action under the United States Fair Labor Standards Act. And then it goes on to quote this other case that says bad faith or groundless counterclaims and other legal proceedings against employees who assert statutory rights are something you can sue for, okay, precisely because of their in terrorem effect. In terrorem means something that makes you go, oh my gosh, I'm going to run away. I'm going to drop this suit. I don't want to deal with this. This is too much for me. Well, employers know that, and that's called in terrorem. So it's like, okay, let's terrorize this person. This person, we'll sue them for $1 million, and then they'll freak out. They'll run away. If we countersue them, the countersuit will have an in terrorem effect. So anyway, that would have a chilling effect and against other employees. So that's another exception to the rule. I know it's a lot of gobbledygook, but I hope that gives you kind of a general notion about these claims. I'm Greg Smith, and you have a great day.